the Queen versus D.L.W. Mark K. Levitz, QC, and Laura Drake for the appellant. Peter Sankoff and Camille Labchuk for the intervener animal justice. Eric Pertsky and Garth Barriere for the respondent. There's ban on the publication, restricting the publication, broadcasting, or transmission of any evidence that could identify the complainant, witness, undercover officer under 486.4 and 486.5 of the Criminal Code.
Good morning, Justices. The intervener animal justice is here today to speak on behalf of the animals who play a critical role in the bestiality offense. Whatever this court decides, we can't forget that it is impossible to commit bestiality without taking advantage of a vulnerable animal that cannot legally consent and is incapable of resisting because of the physical power imbalance between humans and animals. And that is one important reason why the broad approach to bestiality proposed by the Crown should be adopted by this court. Now, the appellant and the respondent have very different views about bestiality, but they seem to agree on one thing, that this offense has nothing to do with protecting animals from sexual exploitation and avoiding the risks of harm that come when an animal can be used freely for human sexual gratification. And I submit that in addition to being counterintuitive, given the nature of the offense at stake, this approach also conflicts with Parliament's intention. A critical question in this case, as you just explored, surrounds what Parliament was trying to do in 1954 and 1955 when it separated bestiality from its historical attachment to buggery. Well, one thing we know is that Parliament was thinking very carefully about animal protection at that time when it made this change. In fact, legislators were showing most concern for animals in Canadian history. Even to date, there has been no amendment more significant made to the Criminal Code than at that time. And the whole purpose of that was designed to extend the protection for animals from being the subject of unnecessary suffering. Now, these changes belie the suggestion that Parliament had no interest in the protection of animals when it was making these changes. And when you consider the important scope and the dramatic nature of the changes that were made, which are outlined in my factum, it's hard to imagine a clearer indication by Parliament that it was concerned about animals when it made this particular change. And I believe it's reasonable to suggest that this was also an animating concern for a broader vision of bestiality. Now, Justices, for that part of my argument involving Parliament's intent, I'm content to rely primarily on my factum. And the reason is because with my limited time, I wish to concentrate on an alternative way of looking at this particular offense, which assumes that the major focus of bestiality is not animal protection, as I've just suggested, but that acts of this kind are wrongful because they constitute immoral acts that are conflict with fundamental Canadian values, which is along the lines of what this Court suggested in Malmo-Levine and Lebay, that it's a crime of morality, and both sides seem to agree that this morality is at the heart of the bestiality offense. The interesting thing is everybody disagrees about what makes it immoral. The respondent has suggested it's about hygiene, and the appellant has argued generally that it's about the disgusting nature of the acts. But this is not the first time that the Court has had to interpret a morality offense with an undefined scope. And I do rely, as Justice Abella suggested, on the cases of Butler and Lebay. They are not identical to what we're considering here, but they do provide an analytical path forward when we're trying to look at what a morality offense is designed to do. And I say these cases are different from the case that we're looking at today, primarily because both of those crimes had the potential to trespass onto valuable types of protected human conduct if they were not properly confined. And also because any interpretation that was based solely on morals in that context ran the risk of being exceptionally vague. But they're still useful because what they tell us, most importantly, is that morals offenses will lose meaning completely if they simply entrench the attitudes of an earlier time. So even if the respondent is correct that the moral focus of this crime was hygiene in the 1800s or even the early 1900s, that doesn't matter today. That is not, we're not restricted in interpreting the morals offenses because the morals offense will lose value if we entrench the attitudes of an earlier time. So I suggest that the moral values cannot be frozen any more than they were for indecency or obscenity. Approaching the law in any other way would totally pervert the application of the offense and lead to the entrenchment of values that are no longer consistent with Canadian morals. So I suggest it may well have been as recently as 1954 that Canadian morals only required bestiality to constitute buggery, the same basic value. But this is 2015, and our moral values have changed, and the content of the offense needs to be adjusted accordingly. And morality offenses are permitted to draw content from the present, and I draw your attention to paragraph 17 of my factum, where a quote from the Justice Friedman in the Dominion News case, in an excerpt that's adopted by this court in Butler. And he's talking about community standards, but community standards was simply the interpretation that was given to obscenity. That's really what it was, the community standards test. That was a judicial interpretation, recognizing that community standards must be contemporary. And in the last line, we cannot and should not ignore these present-day attitudes when we face the question of whether the materials are obscene according to our criminal law. Now, obviously, moving and looking at the moral values of the present is not the only thing, and this court has already expressed concern about providing fairness to offenders. And Labay provides us with information on how to deal with that as well, because Labay was dealing with indecency, which was a broad and open-ended offense. So you can't just be premised on abstract ideas about this conduct as immoral or abhorrent. Instead, we need to look at the extent to which the offense is grounded in fundamental Canadian values, which in this case, I would suggest require a broad construction of bestiality. And I would suggest that two values in particular stand out and need to be assessed. First, there's overwhelming evidence that things have changed from 1954, that legislative and judicial attitudes toward the need to treat the animals that are in our care are continuing to evolve, but the general trend is unmistakable. We need to give more care to the animals. We can't take advantage of them unless it's within the context of a legitimate human purpose. And the landmark changes across every Canadian province, concerns about psychological stress. We're looking at different types of duties and obligations to impose upon owners. And we've even gone so far, or Quebec is at least in the process of going so far, as recognizing that animals are sentient beings and they're not going to be designated in the same way as property. But just as important is the subject of the conduct that's the moral focus here, and that is the sexual use. And this court has repeatedly recognized that sexual conduct should not be imposed on those who cannot consent or resist, over and over again. And I make clear that this is not only about harm, and the case law makes that clear as well. It's about protecting the vulnerable, whether they're harmed or not. So when we're concerned, as this court was in J.A., with complainants who are asleep, the issue is not solely whether they're harmed when that sexual touching takes place. The concern is as much about protecting them from the vulnerability as it is about harm. And the conduct is wrongful because of the risks at stake when that conduct takes place, and the potential for exploitation that exists, even if harm doesn't result in a particular case. And we might recognize that some children, for example, who are of an older age, might consent or might agree to take place in sexual conduct and might not be harmed. But that doesn't mean we allow it to happen. We recognize that the risks for exploitation across the class are too large, so we need to protect them because of their vulnerability.
Why isn't that covered by Section 445, the cruelty to animals?
There's a lot of reasons why, but the first reason it's not covered is because Section 445 requires pain and suffering to the animal. And there will be many forms of sexual conduct that don't provide an obvious form of pain and suffering. But I would suggest that the exploitation still exists, and the moral problem is not necessarily about just the harm to the animal. We are concerned as much about the conduct of the offender towards the animal and about condemning it because it's morally unsettling. And I would suggest as well, I realize that when you combine the heightened concern for animals, which I've already expressed, with a distaste for non-consensual sex between parties, especially where a power imbalance exists between them, the idea that our moral values require a prohibition upon sexual conduct is really not that far-fetched. It's actually exactly what this Court has suggested in lots of different contexts. And again, I realize that animals are different, and they won't always be harmed in the same way as humans. But again, extending the proposition that we shouldn't allow offenders to have license to do whatever they wish to an animal is very consistent with the statements this Court has made in a lot of related conducts. Because ultimately, what the respondent is asking for is an interpretation that gives people complete license to use animals for sexual gratification. And I would suggest that's contrary to modern moral values that has been expressed over and over again, both by this Court and by legislatures across the country. So in short, as my time is running very short, I realize that animals are different from humans. They're not exactly identical, and there are different forms of harm that they will endure by going through this conduct, and in some cases, they may not be noticeably harmed at all. But at the end of the day, I'm not asking you to give animals the right to vote. I'm not asking you to extend principles that go well beyond what this Court has already recognized. I'm simply asking you to recognize that the morality of today certainly gives animals the interest in being free from sexual exploitation. So thank you very much, Justice, for hearing from us today.
Thank you, Mr. Sankoff. The Court will take its morning recess.